Thank you. Y'all are very kind. Thank you very much, John, and Rogers and Jay. Appreciate y'all's very, very kind remarks. It's great to be here with this great organization. I did notice. Let me back up a second. There are three of my former colleagues here from my U.S. Attorney days: Bob Schroeder and who else? John Malcolm and Tom Beaver are all here. And as we were walking in, and the reason I mention this is one of the words that I thought Bob Schroeder mentioned to me that he had read in an article that mentioned me recently. I thought he said soft-spoken, and I said soft-spoken, and he said, no, that isn't what he said. And I noticed also, John, that was not one of the words that you used to describe me. But the other words are very, very much appreciated. We've tried to accomplish an awful lot up in Washington over these last 3 years, and I'll talk a little bit about one area, and that is tort reform. But more than speaking about what we've accomplished in tort reform, I think are some of the tremendous opportunities that we have in that area. But before I do that, let me share with you something that I saw in today's paper. This is a Marietta paper. One of the columns that I read every day, because it's fairly interesting, is sort of today's highlights in history. The Marietta Daily Journal every day runs that, and the top highlight that they have today is the fact that on this day, December 17th, in 1903, was the famous flight at Kitty Hawk by Orville and Wilbur Wright. And in reflecting on tort reform, one shudders to think of the problems that Orville and Wilbur Wright would have had if they had done that today, as opposed to back in 1903, when they didn't have to contend with OSHA and CPSC, and HCFA probably would have gotten in the act, to say nothing of EPA, FAA, and then of course the trial lawyers would have been close behind, asking both Wilbur and Orville if they could do something about their whiplash. But that is very, very interesting, thinking back historically of some of the things that gave rise to the greatness of America. If we had to put up back then with the regulatory burdens, the interference, and the anti-competitiveness of the federal regulators, one really can ask very seriously whether or not we would have accomplished nearly as much as we have as a country that has become the leader of not just the free world, but the leader of the world these days. Tort reform is something that everybody here I know is very keenly interested in, and it's not just because there are so many business leaders here. Tort reform and the problems of tort reform go far beyond simply strictly business issues. Certainly it is a cost to business to deal with litigation. Not just any litigation, but the litigation, the mushrooming litigation, very expensive litigation that we witness in this country, both historically but particularly in recent decades. But knowing of the indirect damage that is done by runaway torts in this country, runaway litigation, you know that the damage that is caused by that phenomenon, which is, if not uniquely American, very nearly so, goes far beyond simply the specific costs, the products that don't make it to market, the products that are taken off of the market, the hesitancy on the part of many corporations to engage in what would otherwise be very productive, competitive enterprises because of not just the threat or the possibility, but the certainty of very costly tort litigation, is something that really is harming this country in ways that escape the average consumer, and indeed many of our colleagues that aren't as active in organizations such as this one and others, such as Southeastern Legal Foundation, which many of you all are involved in and certainly aware of as well. And that was why that in 1994, which I do consider very much of a watershed in modern American political history, why as one of the key components of the Contract with America, which was an effort by Newt Gingrich and the other leaders in Washington, drawing heavily on input from state leaders, state business people, politicians at the state level, they developed the Contract with America, which was not something that was just sort of made up out of thin air, but based on very, very real experiences and input from probably tens of thousands, if not more, Americans, business people and political leaders. And what they tried to fashion in the contract with America were not issues that were fringe issues, not issues that were going to capture the right or the left wing of any political party or political movement, but mainstream issues. And each and every one of those, of course, was precisely that. And one of the cornerstones of the contract with America back in 1994, and a very visible one because of its importance, was tort reform. And indeed, once the Republican majority for the first time in 40 years took over the leadership of the House of Representatives in January of 1995, that contract with America became the legislative agenda for the first 100 days of the 104th Congress, and one of the important components of that was tort reform. And very suddenly, an issue that had been at best on a back burner during the previous 40 years under the leadership in the House of Representatives was catapulted to front burner. And it was debated fully in the Judiciary Committee on which I served, as well as on the floor of the House, and passed by the House of Representatives. So very suddenly, an issue that had not been able to even get a legitimate hearing in committee for decades was on the floor of the House. Then it went over to the Senate, and after a period of time, as the Senate does with things, they moderated it. But still, it was an important piece of legislation. And although we did not have enough votes in either house to override the president's veto, it was a very expected veto, of course, with the influence of the trial lawyers with the White House, having two lawyers in the White House, et cetera. I mean, it was not an unexpected thing that happened when the president vetoed the tort reform legislation, even though it was scaled back considerably to what we had passed in the House and scaled back considerably to what American businesses, industry, and governments needed. It was vetoed by the president, and we were not able to override a veto. And a lot of people, I think, as a result of that, felt, well, we've lost the battle for tort reform, now let's go on to other issues. I would caution against that, and particularly in thinking a little bit about being with you all this morning. Dan Levinson, my chief of staff, who's here with us today, and I were talking about where do we go from here in terms of tort reform, and really, despite the fact that we were not able to get the major piece of tort reform legislation through in the last Congress, signed into law, and even though there was a great deal of disappointment surrounding that, I think there have been a lot of incremental steps that have been taken in the direction of tort reform that really have laid the groundwork now so that we can, if we marshal our forces, if we organize ourselves, and if we view this as a very long-term but winnable struggle, I think there is great cause for optimism in the fight for tort reform, for meaningful, reasonable tort reform in the American legislative and indeed judicial system over the next probably decade. And I think we ought to really commit ourselves, and we're poised here in Georgia because of the tremendous support and many prestigious defense lawyers, insurance companies here in Georgia, and many key corporate citizens, not just for Georgia, but national corporate citizens such as Home Depot that has been in the forefront of this effort. We're really poised here in Georgia to take a leadership role in that. Everybody here, of course, is familiar with a lot of the specific goals and the general goals as well of tort reform. But let me mention just a couple of things that I think are key to keep in mind and not focus simply on the fact that because of the president's veto and because even though the Republicans have a majority in both houses of Congress, it is not a veto override majority, why I think would be a mistake to focus on just that aspect of tort reform and instead focus on some of the specific things that have happened and are happening that I think do augur very well for further very significant gains step by step by step in the area of tort reform. Even though we were not able to get the major piece of tort reform legislation through in the 104th Congress, we did, as many of you all remember, override the president's veto. I think this was the only veto override in which we were successful in the 104th Congress on the Securities Litigation Reform Act, which is now public law. The The House then went on and in a couple of very specific areas followed not only with that, but other aspects of tort reform, the Biomaterials Access Assurance Act, the Product Liability Reform Act over in the Senate. And I asked Dan where he came up with this, because I wasn't even aware of it. We had passed, and it was signed into law in 1996, the Cruise Ship Liability Act, which provides important tort reform relief for cruise ship operators. We then, also in the 104th Congress, last year, as a matter of fact, 1996, passed both houses of Congress, and the President signed the Good Samaritan and Food Donation Act, as well as the Volunteer Protection Act. And the reason that these are important is not just in and of themselves, in that it assists a particular component of our society that has been held back from realizing its potential in helping citizens because of the problems of tort liability. Certainly these particular pieces of legislation that provide much needed relief for volunteers, for example, are important. But I think it's also important in looking at the larger picture of tort reform, because what we're doing through passing these incremental pieces of legislation is educating the American public, getting them used to seeing and thinking about tort reform in ways that affect them day to day. Many Americans cannot say, I mean, even though if they're made aware of the fact that there was a $4 million punitive damage award because somebody felt that the finish on their car was not what it ought to be. That makes the newspapers, and people are aware of that. It sort of has some shock value, but it doesn't necessarily mean anything to them in their daily lives. But pieces of legislation like the Good Samaritan Food Donation Act, the Volunteer Protection Act of 1997, do, because there are real people in real communities all across America that conduct themselves in these areas, that participate in these sorts of activities, and when you are able to provide for them meaningful tort reform that enables them to do more, then it sort of brings it home. And the more that we can do that, the better. Being able to seize on those particular type of issues where tort reform is needed that have a great deal of surface appeal, which would make it more difficult for the administration to successfully veto a piece of legislation, so much the better. So we can sort of build up a head of steam in some of in tackling the major problem of tort reform and product liability reform by taking some of these smaller steps first that I think do lay a very solid groundwork for that. It's also interesting if you look at the way the political landscape and the alliances are changing in Washington. Certainly it became very apparent to a lot of us active in different areas of reform legislation in the 104th Congress that the old strict party lines were no longer the mode. And I know Rogers and Jay and a lot of you all are involved in working with Congress, and on the one hand, having these old alliances sort of break up and new alliances come together. You see new demographic groups, geographic groups. You see conservative and liberal, not so much Republican and Democrat groups coming together on various pieces of legislation, whether it's criminal justice legislation or tort reform. On the one hand, it makes it a lot more difficult to really tell where is Congress going on an issue and who are the people that we need to be in touch with in order to make sure our viewpoint is known and to educate those members. So on the one hand, it makes it tactically a little more difficult for lobbyists, but more importantly, from a strategic level, I think there's tremendous opportunity there in that no longer do you know that it's absolutely worthless to approach a member of one party or the other because the party line dictates that their position is not one that is compatible with yours. There's a lot more opportunity when you look at the political landscape to reach different members and to influence a lot of different members, not by approaching it strictly on Republican or Democrat lines. And you see that Dan actually pointed this out to me, in some of the legislation that is pending, that's been introduced over the last couple of years. For example, S 1554, which is a Senate bill, the Fairness and Punitive Damages Awards Act, and it's introduced, two of its co-sponsors are Senators Hatch and Lieberman. Not only different parties, but completely opposite ends of the political spectrum, very conservative and very liberal. And you see that in other legislation as well. So I think one thing that we ought to and we need to keep in mind in approaching the issue of tort reform is not to think stereotypically in terms of Republican or Democrat. There's a lot of opportunity now as the public becomes more aware through the work of organizations like this organization, hopefully the Chamber of Commerce, the U.S. Chamber of Commerce, our state and local chambers of commerce, and through some of the court decisions that have come down recently, as the public becomes more and more aware of these things and puts more and more pressure in specific little areas brings pressure to bear against members of Congress, it's not going to break down on strictly party lines. So I think there's a lot of opportunity there, and we sort of have to develop a new way of thinking of how to approach members of Congress on these things. There have been, as I mentioned, some decisions recently that in the court area that I think do bode well if we can maintain the current makeup of the court, the Supreme Court in particular. I think that we will continue to see more reasonable limitations placed on class action lawsuits, for example. Now, the wild card in this whole thing, and I can't tell you with any degree of certainty how it's going to sort itself out and what the ramifications are, of course, is the tobacco settlement. We'll just have to sort of watch that one develop. I mean, not passively, but kind of see how it develops and work it through. I'm sure we'll have in the coming session, Dan wouldn't be surprised if we see some of that come before the Judiciary Committee. Likely, and of course the Commerce Committee. So what effect that will have on all this, I really don't know. That's sort of a wild card. But looking at some of the court decisions recently and looking at the legislation that's been introduced out there and some of the incremental steps that we've taken in tort reform over the last 3 years of this Congress, and building on the fact that tort reform was a very important conscious part of the contract with America, I think that there is an awful lot that we can be doing over the next few years if we organize ourselves. The movement for tort reform, for product liability reform, is not well organized. Dan and I have both noticed that in meetings that we attend up in Washington. We're not getting the high-level persons. We're not getting the member involvement. Despite the fact that there are certain key members both in the House and the Senate, including Paul Coverdell, who are very active in this area. A lot of the meetings, a lot of the movement up in Washington is not being driven by the people that really need to drive it, your top-level people, your senators, your members, your top lobbyists. And I use the word lobbyists in a very positive sense, those people who are active in working these issues in the Congress, who understand the procedures and the personalities up there. So I think that one thing we need to do, those of us here, probably everybody who is active in one way or another with a national corporation, a national organization or interest group, needs to do everything they can to get the folks in Washington more motivated, more involved on this issue, because I think there's a lot of opportunity. Part of the problem is a lot of the folks in Washington look at the big issue. And if they look at tort reform in terms of a big issue, they see the fact that, well, with this administration, there is no way that we are going to get tort reform through, so let's just sort of put that aside and move on to other issues in which we have maybe a greater immediately perceptible chance for success. And I think that's a wrong way of looking at it. But that happens in Washington sometimes, and I think particularly here in Georgia, we realize that that is not the way to go. Georgia has made tremendous strides over the last decade in tort reform at the state level, and as I mentioned, a lot of our corporate players are very active, not just in Georgia, but nationally on that as well. And I think we really ought to try and focus that energy and bring more of a focus to Washington, because right now it's sort of in disarray. And I think if that continues, we're going to miss a tremendous and very historic opportunity to really move forward on tort reform. It's going to require also a lot more than just grabbing a headline now and then. It's going to take a lot more than just going after the trial lawyers sort of thing. That may be good for a headline, it may be good for a political soundbite every now and then, but the issue goes a lot deeper than that, and I think we need to resist the effort to sort of go for the headline, go for the soundbite, and really focus on putting together a very long-term, well-organized effort to both focus on the end goal, but along the way to put together a series of very small steps, very small victories, and educate the public a lot better on these things, because it is going to it's going to take a little bit of time, but I really think that if we seize the opportunity, there's a tremendous likelihood for success in the not too distant future. Certainly the political landscape, the political environment will have something to do with how quickly that happens, what happens in the election of 2000, for example. But I think in large part, those of us who believe in the need for tort reform to free up not only our economy, but many social programs that we're interested in, really ought to seize the initiative now and do what those on the other side, such as the trial lawyers, have done for many, many decades, and that is to mount a very constant, very effective effort both at the national and the state level. We need to play their game, but play it better, and that should not be hard to do because we're right on these issues. We're on the side of the American people, on the average citizen of this country. We're on the side of the small business in this country. We're on the side of large corporate America as well. And we're also on the side of local governments that are being pounded by tort litigation as well. So I think, in conclusion, there's a tremendous opportunity right now if we look at it in the right way, if we don't lose sight of the forest for the trees, if we keep a long-term perspective, and if we organize ourselves well. And I truly believe that Georgia is poised to take a leadership role in that. Dan, over the course of the last year and a half, has had 2 or 3 meetings with a number of the insurance folks, some of whom are here today, a number of defense lawyers and insurance lawyers, to try and organize ourselves here at the state level and provide the support that we need in Washington. When I say we, I mean both me personally as I work through these issues on the Judiciary Committee as well as other members as well. And that effort will continue, and your participation in that, if anybody would be interested in helping out as part of that effort, please let Dan or I know, because that, again, that organization is going to be very, very critical. With that, Rogers, you say we have a little bit of time, and I'd be more than happy to touch on a number of issues. And Dan certainly is available also. He follows actually the details of a lot of this effort even more than I do. We also have Brad Alexander with our office. Brad is in law school. The conditions under which he goes to law school are that he will not become a plaintiff's lawyer. He will become a defense lawyer, and we appreciate that. And Fred Aiken, who many of you know through his work in the General Assembly and in private industry, is with us today, our district director, and I appreciate them being here as well. But Rogers, if that would be appropriate, I'd be more than happy to take questions on anything that I or we are involved in up there, or just something that we ought to be involved in. Ken?
Talk about the reason for impeachment of President Clinton.
Several, I guess just over a month ago, myself and a number of other members filed in the House shortly before we went on our district work period an inquiry of impeachment against the president, and it's come up in a number of settings since then. The reasoning behind that, the reason why myself and other members decided that it was time to file an inquiry of impeachment, which is not articles of impeachment. I don't think we know quite enough yet to really fashion that, but an inquiry of impeachment to simply begin the process of looking into the impeachment of the president. It's something that developed in my mind and in the minds of a lot of other members over the course, primarily the last year, as the Fred Thompson Committee really brought to light, I think, a tremendous body of evidence of wrongdoing by the administration and those connected with it, contrary to a lot of the Washington pundits who proclaimed the Thompson Committee either dead on arrival or dead at the time they concluded their effort and a miserable failure. I think that it was tremendously successful in bringing some very, very substantial, substantive evidence to light. Also, the work that we've been doing in the Judiciary Committee and the work that also on the Government Reform Committee, and I serve on both of those, the only member, just coincidentally, that serves on both Judiciary and Government Reform. Looking at what we see developing, it became apparent to me, and we have 3 very, very learned prosecutors and former prosecutors here, What they look at and what I look at when I look at evidence is not one little tiny discrete piece of evidence that is in a cubicle and then you move on to the next one. You see a pattern of activity. And that is why, in fact, many of the charging instruments by U.S. attorneys are cast in the form of a conspiracy, a racketeering, continuing criminal enterprise, and so forth, because that indeed is what most of these people engage in. It's not one discrete act that they conclude and then they move on to the next discrete act and then another. It's a continuum, and that's what we see. If you look at what is developing, you see, I think, very clearly a conspiracy to evade the election laws of this country in the worst way possible. It's one thing to sort of shave a corner here and there, and that would be bad enough. It would be another thing to deliberately flaunt the election laws with regard to domestic money. That is very serious. But what we're witnessing with this administration over the course of the last election cycle primarily is moving into an area that is completely uncharted in American history. We have never seen before what, by every appearance, is a deliberate effort to bring foreign money into our electoral system. I can think of nothing that is more serious nor more damaging than that if it's allowed to continue or to go unchecked. So looking at all of the evidence that we've developed in those areas, as well as having to deal with the constant obstruction of our efforts to get at the truth in the Congress, led me to the conclusion that the one way, the only way that is available to the American people is the one way, the only way that was given to us by our founding fathers 220 years ago in the Constitution, and that is impeachment, which is a mechanism to look into these very sorts of things and to simply remove somebody from office if they are found guilty of engaging in these sorts of abuse of office. So it was on that basis and with that background that we filed the inquiry of impeachment and are pushing to make that go forward, just so we at least have the opportunity to focus the effort where it ought to be focused in a way that it ought to be focused as laid out by our founding fathers.
Congressman, I think we all support your tort reform, going back to communicating law. But to get a broader base and get more general public support, are you supporting or tying it in with insurance reform? Because I think it's a two-edged sword.
Insurance reform in what context? Not what we're working on in the banking committee, or are you talking about that or some other aspect of insurance reform? There are several efforts in this area. Dan, you may want to talk to that. There are a couple of specific efforts that I think do tie in directly to it with regard to consumer-oriented pieces of legislation to reduce the cost of insurance. But Dan, maybe you could address that. Are there any other specific measures? I think it's a very good point.
There's a particular initiative that the majority leader Army has advanced on auto choice to try to separate the economic from the non-economic matters on auto insurance and see whether it might be worthwhile for consumers to have a choice to in effect opt out of a Allstate system and perhaps reduce the premium state by state if indeed you can limit the kind of insurance coverage you receive so that if you are in an accident, you won't have the opportunity necessarily to go to trial and establish fault and perhaps receive punitive damages, that you'll simply receive a compensatory injury and property damage you have suffered. The auto insurance bill has been in effect endorsed by the Joint Economic Committee as something that would be very beneficial in terms of reducing insurance premiums, reducing in effect the transactional costs of auto insurance. In that sense, that is one example of an industry-specific effort to take a tort reform effort and show how, in one context, it can make a big difference to both businesses and consumers.
The Georgia Board of Pardons and Paroles just announced a new effort to increase force most violent criminals in Georgia to 90% of their sentences. This is going to be something that's going to be debated in the legislature next month. Would you like to comment on that?
One thing that we have tried to do in a number of different pieces of legislation, both in appropriations bills as well as in specific bills oriented toward prison reform and sentencing reform, in this Congress, and by this Congress I mean not just the 105th but the 104th, is to try and use the appropriate role, not of federal government mandating something, but the appropriate role of the federal government providing support funds for state law enforcement, for example, to encourage states to do something that Georgia has done to a much larger extent than other states, but still not to the extent that we would like to see, and that is to institute sentencing reform. One of the first things that I was called on to do as a U.S. attorney back in the mid-1980s was to testify with regard to the federal sentencing guidelines, which then went into effect in, Tom, when did those go into effect? 87? That went into effect in 87, and despite all of the doom and gloom folks and the chicken littles and all of the other folks that were very comfortable with the status quo, that the sky was going to fall in, that our prisons, federal prisons, would become absolutely unburdened and busting at the seams and so forth, none of that happened, and the system has worked remarkably well. And what has made the system work remarkably well is certainty. People know that when you go into the federal system, at the time you're charged with a crime, if you're convicted, you know what time you're going to do. There is very little leeway. There is some leeway, as you always want to have, for the prosecutors and the judges and the defense as well, to make a case for a judge to go outside of the guidelines. But unless that case, and there is a heavy burden, unless that case can be made, there is a great deal of certainty. And that helps not only the defendant to know what it is that he or she is facing, it helps the prosecutor plan their caseload, but it also is a great assistance to the U.S. Bureau of Prisons, so that they can plan with a great deal more certainty because they know precisely how long people are going to be in the system. And the ultimate beneficiaries of that are, of course, the citizens, who know that these people are going to be off the street for a definitive period of time, and they're not going to be coming back until they have served their time. We have tried in the last Congress and in this Congress to tie in the provision of certain federal law enforcement monies, significant amounts, to states instituting stronger sentencing measures along those lines. Not that they have to precisely follow the federal model, but to institute definitive sentencing procedures in their states. For some reason, and I still have not figured it out, this administration does not like that approach. They much prefer the approach of having just as much as possible administered through the federal government, the Department of Justice and various components thereof, flowing through state bureaucracies. So you don't have the flexibility, you don't have the tie-in and so forth. So if Georgia is indeed getting more serious about it at the local level, is Randy still here? Randy Souter is here, one of our state reps, who I know is very, very supportive of that. I think that will help not only Georgia citizens, but help in our effort to do more and more of that encouragement at the federal level as well. So I'm glad to hear that. Gould? Well, I don't know, Dan, have you heard that? That he's had a falling out with trial lawyers?
So much that he's had a falling out is that there has been some progress made in being able to get some reform proponents in the Senate together with Chris Lindsay and others in the White House to talk about a products bill for 1998, and that there was some optimism expressed that there might be some compromise reached on statutes of repose and a couple of the other important issues, punitive damages, that have been on the agenda for quite some time. Whether that is triggered by some specific falling out with one or more trial lawyers, I certainly have not heard anything.
If it is, I think it's an additional opportunity, and what we need to be able to recognize those opportunities and to seize them. I mean, having an opportunity really is just the start of a process. What we need to do is have an organization and a focused effort to sort of follow in behind that. So I hope we do that, because that can be a significant advantage.
It's certainly true that one thing that remains a very stable part of the environment is the contributions by trial lawyers to the political process in Washington. It is completely out of proportion to any other interest group imaginable as far as contributes in advancing which particular cause.
thing that we need to do is again, recognize that tort reform goes far beyond simply products or medical liability. With the, I think it was one of the RAND studies recently, looking at punitive damages in non-tort cases, contract cases, for example. There is, I think, there's been a doubling into $3 or $4 billion just over the last decade in the amount of punitive damages in non-tort cases. That affects real estate, for example, brokers, much more than in the past. So there are a lot of other groups out there that historically or traditionally have not so much thought of themselves as a key player affected by the problem of tort litigation in this country, and correspondingly one of the beneficiaries of tort reform, that now really do need to think of themselves as part of that equation, and we need to organize them as part of this effort as well.
Two things I want to say. First of all, thank you for the constituent service you provide, even the smallest county in your district, and I don't think maybe people realize how large your area is, but I am thank you for that.
Thank you.
My concern is plea bargaining. As legislators, the stricter our laws are, seems there's a back door called plea bargaining, whereby someone can very effectively plead to a lesser sentence, and we're not addressing really some of the problems we're trying to address because of that system in place.
It's probably one of the more difficult aspects of our criminal justice system to deal with. You want to provide some flexibility for your prosecutors. Otherwise, the system would literally just cave in on itself. But you have to recognize also that any system of criminal justice is only going to be as good as the people who are elected or appointed to carry it out. And there is no substitute for making sure that the citizens and the interest groups, such as the state legislature, track these issues, track how our prosecutors are doing, whether there are plea agreements, and particularly looking for a pattern of plea agreements that seem to undermine a legislative intent. This was a problem that we were constantly reminded of by Attorney General Meese and then Attorney General Thornburg, that with the sentencing guidelines, that we were told, even though there is a safety valve, there's great power that a federal prosecutor has in fashioning the charging instrument, which will determine very precisely the sentence, that the policies of the Department of Justice were not undermined by the use of that tremendous power. So we were monitored and had to follow certain guidelines. I think it's very important for the state to do that as well. In other words, make sure that state prosecutors, the district attorneys and solicitors in Georgia are not undermining the policies set out by the legislature in setting its mandatory sentences, minimum sentences, and so forth. And if it does need to be tightened up, I think it ought to be. But the most important thing is as you just I think indicated impliedly, we have to monitor those things because it can very, very subtly but very profoundly undermine the will of the people as reflected in the state and the laws that are passed. Rogers, can we take one more question? Dr. Funk.
Whatever happens in Judge Riverdale's concept of punitive damages for punishment for egregious wrongdoing, and that this wasn't a matter of the plaintiff receiving the benefit of punishment, but rather the state getting the money. We could remove punitive damages from the money that accrues to the plaintiff's lawyers and assign it to the state, as he, I think, one time proposed. That would cut down the punitive damage, excessive punitive damages. It seemed to me to be a major function of our system.
Georgia actually has done that and is one of those areas where Georgia is sort of ahead of the power curve with other states. Maybe one of the other lawyers here in the audience that is familiar more specifically, I don't know, Tom, do you get involved in any of that sort of work as defense attorney?
Well, we do from time to time. You are correct. And in Georgia, we are ahead of the power curve because that's what is in place now. Many other states don't have that, so I think we're on target in that area.
Yeah, so, and what we need to try and do, we not so much from a legislative standpoint in this regard, but business people, doctors like yourself and so forth, through our trade organizations, is encourage other states to do what Georgia has done. And that will have two benefits. One, it will help the citizens of that state, but it will also provide tremendous momentum and support for what we're trying to do in Washington. It's one thing if you have 1 or 2 states that have done that successfully and the numbers can prove it out. It's quite another if you have 25 or 30 or 35 states that have taken that step. It becomes then almost impossible for Washington, for the Congress to ignore. Rogers, thank you again. It's an honor to be here. Thank you all very much.